Today's topic: deciphering statements, admissions and confessions. Welcome to Nyay Pathsala. In every episode, we discuss various legal principles and landmark cases, making the complex world of law accessible to all. In order to clear the misconception in regard to the fundamentals of statements, admissions and confession, it is necessary to have a discussion on it to have clarity over these expressions. And considering the importance of the topic, I have decided to divide it into two parts. Part 1 will contain statements and admission vis-à-vis right to self-incrimination. And in part 2, I'll discuss confessions in detail. So let us first understand the term statement in the context of Criminal Procedure Code and the Indian Evidence Act 1872, which pertains to any declaration, verbal or written, made by a person. The word statement has been used in a number of sections of the Indian Evidence Act 1872 in its primary meaning of something that is stated. We should remember that in fact, every confession starts only with a statement. A statement thereafter gets into the form of an admission. And an admission ultimately ends up in a confession. In other words, when there is an admission of confession, then admission becomes confession. If you want to understand admission, you need to look at section 17 and 21 of the Indian Evidence Act 1872. If you look at section 17, it states that an admission is a statement, oral or documentary, or nowadays it is contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances referred hereinafter. Under section 21 of the Indian Evidence Act, it speaks about proof of admission against person making them and by or on their behalf. In the context of section 21, admissions are relevant and may be proved against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or is by his representative in interest, except in the cases provided therein. Listen carefully. An admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it to a death, it would be relevant as between third persons under section 32. Section 32 dying declaration we have discussed in a different video. You may kindly look into that in our video. Next is, an admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body, relevant or in issue, made or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improper. Let us pause here for a moment. In Evidence Act, as I always speaks, that you have to look into each and every word of the meaning of this section. If the meaning is not clear from the section, then you have to look into the precedent or the judgment of the Supreme Court. The next is that admission may be proved by or on behalf of the person making it if it is otherwise relevant than as an admission. So these are the differences between these stages. And when you read the admission under this section, you will be clear in your conception. So now let us talk about statements as referred under section 161, 162, 164 of the Code of Criminal Procedure and section 25 to 27, 30, 32 of the Evidence Act and also Article 20 subclause 3 of the Constitution of India. When we talk about statement, we need to understand statement in the context of the Code of Criminal Procedure. Although it is not directly related, but you have to understand the concept of FIR as given under Section 154 of the Cr.PC. Under Section 154 Cr.PC, you should remember that FIR is an important document under the criminal law procedure, and its main object from the point of view of the informant is to set the criminal law into motion. If you look it from the point of the investigating authority, it is to obtain information about the alleged criminal activity so as to able to take suitable steps to trace and to bring to book the guilty. If you look into the opening words of Section 154 of the Cr.PC, it suggests that every piece of information relating to commission of a cognizable offence. What is cognizable offence? Is that a person can be arrested without a warrant. So every piece of information relating to the commission of a cognizable offence shall be reduced to writing by the officer in charge of the police station. Once the FIR is registered, the investigation of a case begins. Evidence is collected by the investigating authority, and ultimately on completion of the investigation, the final opinion is the sequence which results in the filing of a report under Section 173 Cr.PC. In this context, let us refer to Section 161 Cr.PC. This Section 161 Cr.PC is a very important section from the point of view of statement, because it deals with examination of witness by the police. Section 161 provides a discretionary power to the police officer. What is the discretion? That he may examine orally any person supposed to be acquainted with the facts and circumstances of the case. Kindly pause here. You go to a place of occurrence, the investigating officers go to a place of occurrence and finds there are many persons, but he may not examine all the persons present at the place of occurrence. He may only examine orally first any persons acquainted with the facts and circumstances of the case. And when we talk about any person under Section 161 Cr.PC, it includes the accused also. Now under Section 161 subsection 2 of the Cr.PC, any person who is acquainted with the facts and circumstances of the case is bound to answer truly all questions relating to such case put to him by such officer. And what is the safeguard? Other than questions, the answer to which would have a tendency to expose him to a criminal charge or to a penalty of forfeiture. So if it is a self-implicating statement, he may refuse to answer. Now next, when you go to under 161C subsection 3 of the Cr.PC, it states that the police officer may reduce into writing, here the word uses may reduce into writing any statement made to him in the course of an examination under this section, and if he does so, he shall make a separate and true record of the statement of each such person whose statement he has recorded. That means a relevant witness statement, he has to record it and put it into the case diary. And this is what we refer in common parlance as 161 Cr.PC statement. The question that often crops our mind is that is it a requirement of law that the statement under Section 161 Cr.PC has to be recorded in the language known to the person giving the statement? Imagine a situation, the person knows Hindi but understands little bit of Urdu, and the statement is recorded in English. So is it necessary that this statement has to be recorded in English or in Hindi or Urdu? The Supreme Court in the case of Jahira Habibullah versus State of Gujarat, which is relating to those Gujarat riot cases reported in 2004, 4 SSA 158. In that case, the Supreme Court has observed that it is not a requirement in law that the statement under Section 161 Cr.PC has to be recorded in the language known to the person giving the statement. In fact, as a matter of fact, the person giving the statement is not even required to sign the statement. as is mandated in section 162 CR.PC. So let me pause again. Police records a statement under 161 CR.PC. In that statement, the signature of the witness is not required or mandated as per section 162. So in the case of CCE versus C. Fernandez, which is reported in 1982 3 SCC 512, there the Supreme Court has observed that in case of section 162, if the statement is recorded in an English not known to the accused, he doesn't know English, but if it is read over, translated and explained to the maker in the language known to him, which was Tamil in that case, it is admissible evidence. Similarly, in the case of 2007 2 SCC page 764, State and City of Delhi versus Ravikant, the Supreme Court observed that the section 161 CR.PC, it authorizes the police officer to reduce into writing any statement made by a witness which I have already spoken. However, in a given case, the IO may also record the circumstances ascertained during investigation in the case diary in terms of section 172 CR.PC. We must remember that it is only when the IO decides to record the statement under section 161 CR.PC that he becomes obliged to make a true record of the statement, which obviously will not include the interpretation of the IO of the statement or the gist of the statement. There is a privilege which is given to the investigating officer under section 173 subsection 6 of the CR.PC. Kindly read 173(6) of the CR.PC, where it authorizes the police officer to claim a sort of privilege in respect of any statement recorded under section 161 CR.PC. But he has to give reasons as to why such statement may not be provided to the accused. And you should remember that such privilege can be only claimed in respect of a statement recorded under section 161 CR.PC and not in respect of what the officer records in the case diary, that is the gist of the statement under section 172 CR.PC. We all know that in terms of section 207 CR.PC, once the charge sheet is submitted, the magistrate has to provide to the accused free of cost. What he has to provide? Copies of statement recorded under section 161(3) CR.PC, subject to the exception in terms of section 173 subsection 6. But however, section 172(3) CR.PC also provides that neither the accused nor his agents shall be entitled to call for the diary of the proceedings in investigation, and neither they will be entitled to see them merely because they are referred to by the court. Imagine a situation. This statement is recorded in English and the statement was given in Hindi. There was a case where a prosecution witness have given a statement in English which was recorded in Hindi. The Supreme Court in the case of Manu Sharma versus State and City of Delhi, reported in 2010 6 SCC page 1 paragraph 97, has held that in such a case, in absence of any suggestion to the contrary, it must be presumed that his statement was correctly recorded. The police goes to the scene of crime. Is it mandatory to police to record every statement of every witnesses? It is to be noted that it is not mandatory for the police to record every statement of every witness, because under law it also contemplates situation where there might be witness who depose in court but whose previous statements have not been recorded. And you can refer to that Manu Sharma's case. Obviously, at this stage, a question comes up into our mind that what is the evidentiary value of a statement of a person recorded under section 161 CR.PC. Since we are talking about statement, so we should understand what is the evidentiary value of a statement of a person recorded under section 161 CR.PC. We must remember that section 161 CR.PC statement is governed by section 156 or 157 of the Evidence Act, and to what extent it can be used is specified therein. If you read section 157 of the Evidence Act, it states that former statements of witnesses may be proved to corroborate later testimony as to the same fact. That means in order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. Kindly read section 157 of the Evidence Act, and this will help you in grasping the intent and the content of that section. So the next question which comes up is that if it is a former statement, then how it can be used in a court of law? The answer to it is provided in section 162 of Cr.PC. It states about statement to the police and use of such statement during trial. Under section 162, statement to police not to be signed. Remember it. And what is the use of statements in such in evidence? Always remember that no statement made by any person to a police officer in the course of an investigation under the Cr.PC shall, if reduced to writing, be signed by the person making it, number one, nor shall any such statement or any record thereof, whether in a police diary or otherwise, or any part of such statement or record, be used for any purpose as provided hereinafter in that section. It is also provided that in any inquiry or trial in respect of any offence under investigation at the time when such statement was made, the prosecution can always call for it in such inquiry or trial whose statement has been reduced into writing as aforesaid. Any part of a statement, if duly proved, may be used by the accused. So, former statement recorded under 161 may be used by the accused, and sometimes which we call hostile witness with the permission of the court by the prosecution to contradict such witness in the manner as provided under section 145 of the Evidence Act. So to summarize it, so far section 161 and 162 is concerned, it is that you can use it for the purpose of contradiction, but you have to do it as provided under section 145 of the Evidence Act. And in subclause 2, it is of section 162, if you read it, it provides that nothing in this section shall be deemed to apply to any statement falling within the provisions of clause 1 of section 32 of the Indian Evidence Act. So section 32(1), that is which relates to dying declaration, is excluded from section 162. Or similarly, section 27 of the Evidence Act is also excluded because sometimes it leads to the discovery, and that discovery part is admissible. And also look into the explanation to that section, because in the explanation it says that an omission to state a fact or circumstances in the statement which has been referred may amount to contradiction also, if the same appears to be significant and otherwise relevant having regard to the context in such omission occurs, and whether any omission amounts to contradiction in that particular context shall always be a question of fact. So we must remember the evidentiary value of a statement made by a person in custody. For that you may refer to 2010 7 SCC 26 para 132. This is that famous case of Selvi versus State of Karnataka. In this case, the Supreme Court observed that statements made in custody are to be considered unreliable unless they have been subjected to cross-examination or judicial scrutiny. Under the Code of Similar Criminal Procedure and the Evidence Act, it mandates that confession made before police officers are ordinarily not admissible as evidence. You may also look into section 25 of the Evidence Act to see the confessions or the statement made by the police officer during investigation. And it is only statement made in the presence of a judicial magistrate which can be given weightage. In Selvi's case, the phrase has been used as the doctrine of excluding the fruit of a poisonous tree. And to understand it, section 24, 25 and 26 of the Evidence Act may kindly be looked into. In the Selvi's case, it also discusses the application of the word statement in the context of evidence under the Indian Evidence Act, which was also subsequently referred in Vogilal Chunilal Pandya versus State of Bombay, which was reported in 1958 SCC Online SC 29 in paragraph 6, 7 and 10. Recently, two courts in India had the chance to address the issue of whenever an accused or whether an accused can be forced to give a passcode or password or biometric without violating the constitutional ban on self-incrimination as provided in Article 20, subclause 3 of the Indian Constitution. There is no authoritative pronouncement by the Supreme Court of India on this issue, hence the question is res integra. But the Supreme Court had determined the parameters of the protection against self-incrimination in the landmark case of State of Bombay versus Kathikalu Ogra, reported in AIR 1961 SC 1808. This Kathikalu case is very important. You kindly read this judgment in AIR 1961 SC 1808 against right to self-incrimination. Here the court was required to determine in Kathikalu's case that if giving handwriting, signature or thumb impression samples, whether it violates Article 23 of the Constitution. The court ruled against the accused, noting that a witness can provide both testimonial and non-testimonial, that is physical evidence, and that if an accused person can only be deemed to be a witness against oneself in the former case and not in the latter. And the reasoning was that self-incrimination must mean conveying information based upon the personal knowledge and cannot include merely the mechanical process of producing documents in court, which may throw a light on any of the points in controversy, but which do not contain any statement of the accused based on his personal knowledge. If you look at paragraph 11 of the Kathikalu's case, wherein the court observed the meaning of the phrase "to be a witness," the court observed that to be a witness means imparting knowledge in respect of relevant facts by means of oral statements or statements in writing by a person who has personal knowledge of the facts to be communicated to a court or to a person holding an inquiry or investigation. In this case, if a charge warrant as per section 93 Cr.PC is issued by the court in order to charge a smartphone or a computer system for investigation purposes, the court reasoned it saying that section 91 Cr.PC enables right in favor of the court or officer in charge of a police station to issue summons or to order from a person possession production of any document for the investigation purpose. So ultimately, the court treated a password or a passcode or a biometric as a document as provided under section 91. The court also relied on section 100 Cr.PC to justify that on production of a search warrant, if any person is in charge of some closed place, it would allow free access to the person executing the search warrant. So a person is possession of an electronic device or gadget must always cooperate with the investigating officer by disclosing the passcode to let them gain access to the device. And ultimately, the court in its final assessment found that disclosure of passcode does not constitute violation of the right against self-incrimination under Cr.PC. Rather than it provides a mechanism for disclosure of passcodes and biometric. Of course, the Supreme Court is now also in session of this matter as to how to return the seized electronic devices and all. So unless the Supreme Court decides on this issue will always remain a res integra. Of course, the Bombay and the Karnataka High Court has decided on the biometrics or the passcode of the mobile, etc. So the next question which I would like to consider is that how a statement is to be recorded during investigation under section 164 Cr.PC. So remember this Selvi's case, as I have already discussed here, that in the Selvi's case, which was reported in 2010 7 SCJ 26, the Supreme Court declared several techniques like brain mapping, narco analysis and lie detector tests as unconstitutional. Why? Because they intrude into the privacy of an individual to extract feelings and thoughts for self-condemnation. It further strengthened the protection by holding in Selvi's case that Article 23 creates a zone of mental privacy which the state may not force to surrender to extract personal knowledge about a relevant fact. So to conclude, I thank you for watching Nyay Patsala. Stay with us for part 2, where we will analyze confessions, both during trial and investigation, as well as judicial and extrajudicial confession. If you like our content, please do subscribe to our channel. See you soon. Thank you.